the beneficiary of your retirement account. And it was with most legal questions, there are various factors for us to consider. Before we get to it, I'd like you to imagine a close friend of yours struggling through a what-if scenario that creeps into their lives. But their struggle became a little less because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks. Now first, if you are a married individual, it really is always best to designate your spouse as the primary beneficiary under a retirement account. That's because a spouse does have the longest or most flexibility when it comes to rolling over a retirement account over a longer period of time. And thereby it reduces sort of the overall tax liability typically because you can stretch it out. Now, the law did change at the very beginning of 2020, right before COVID happened. Wonderful year. Where essentially the next generation, so starting in 2020, when the children and anyone in that sort of bracket of age difference between the retirement owner and the recipient, once they receive that account now, they must take it out over 10 years. No longer can you stretch that over the lifetime or expected lifetime of the beneficiary. And in doing so, that forced 10-year distribution means that the IRS gets more money faster. Great for them, not so much for your beneficiaries. So the question still remains, which was asked here, whether or not you should name the individual as a beneficiary or the trust. Again, after a spouse, we would typically guide our clients to designate their revocable trust as the contingent beneficiary, secondary beneficiary. And the reason we do that, of course, we draft our trusts with two specific important provisions that allow for that to provide more protection to the family. And the first of that is that the trust must be created in such a way where it almost ignores the fact that it is a trust, if that makes sense. Because if it were not what's called a see-through trust, where it looks directly to the beneficiaries underneath, if it was a more complex beneficiary mix, including charities or something like that, then the payout would actually shrink even more to only 5 years. And so we do want to make sure that we're drafting this document. That doesn't mean you can't give to charities, by the way. It just has to be drafted in such a way where for the IRA rules and distribution rules, that the underlying beneficiaries are seen as the recipients rather than the trust itself prepared for those beneficiaries. So that they still get the 10-year payout, again, faster than it was in the past. But they still get the 10-year payout, but they'll have the added layer of protection in the way that we draft it, where we have lifetime creditor protection for those beneficiaries. And so the monies from the retirement, while they may have to come out of the retirement account for income tax purposes over that 10-year time frame, the principal can still be held under the beneficiary's trust created under your plan. And that can offer them lifetime creditor insulation if they don't remove it from that their trust that was created under your trust. You know that maybe I'll have to draw an image someday, but if you can imagine your trust is the top umbrella and then each of your beneficiaries sort of have their own trusts underneath, those have creditor protection and can still apply to retirement benefits if it's done in the right way. Of course, as you can tell, this is a little bit intricate, and it's a great idea to talk this through with a professional who understands what they're talking about. We could do so in New York, New Jersey. If you'd like to reach out to us, yourplanningattorney.com is a great way to do so. So we hope you've learned something new here today and you choose to share. And as always, please take care.